Hello everyone and welcome back to day 5 of Polity Daily Drill. Let's begin our questions for today. First question. Consider the following statements. Advice of Council of Ministers binding on the President, fixing the maximum strength of Council of Ministers, reduction in voting age from 21 to 18, obligatory on the President to give assent to constitutional amendment bills. What is the correct sequence of events from earliest to latest? Let's arrange these events, marking in front of them the year in which these changes were done in the Indian Constitution. First up, Advice of Council of Ministers binding on the President, Article 74 was modified through the 42nd Amendment Act of the year 1976. Fixing the maximum strength of Council of Ministers, so the maximum strength was fixed at 15%. Article 75 was modified, Clause 1A was added. Article 164 was also modified with the addition of a clause there, and this was done through the 91st Amendment Act of the year 2003. Third one is the reduction in the voting age. This was done under Article 326, the change made through the 61st Amendment Act of the year 1988. And finally, Article 368 was modified, making it mandatory for the President to give assent to constitutional amendment bills. This was done through the 24th Amendment Act of the year 1971. This means this is the earliest event, number 4, and this is where you have number 4. B is the right answer. This was the first event, number 4. Then we had the second event, number 1, then we had the third event, number 3, and then we had the fourth one, number 2. 4, 1, 3, 2, B being the right answer. Moving on to the second question. Consider the following statements. Nominated members of the houses are not debarred. Debar means to not allow, disallow. Not debarred means they are allowed. So nominated members of the houses are not debarred from being appointed as a minister. And second one, to be the prime minister, the person has to be a member of Lok Sabha only within 6 months from the date of his appointment as prime minister. Now, in our country, there is absolutely no need for anyone to be a member of Lok Sabha only or Rajya Sabha only or be only elected member or a nominated member to be a minister, including prime minister. In fact, you don't even have to be a member of the house. Any person can become a minister, including the prime minister, for a maximum period of 6 months. Within these 6 months, the person must get himself or herself elected or nominated to any house. This means to be the prime minister, the person has to be a member of Lok Sabha only is wrong. He or she can be a member of Rajya Sabha also. And of course, nominated members are not debarred, they are allowed and they can be appointed as ministers. Making first statement correct, second one wrong. Which of the statements given above is or are incorrect? Please don't forget this is incorrect. Right answer is B, 2 only. Moving on to question number 3. The Chief Justice of India is called the Master of the Roster because he appoints officials and oversees general and miscellaneous matters relating to the supervision and functioning of the Supreme Court, or he is called the Master of the Roster because he is the head of the collegium system, or he is responsible for the allocation of cases and appointment of constitutional benches in the Supreme Court. We know that the Chief Justice of India is called the Master of the Roster because he is the person responsible for allocating the cases. He is the person responsible for deciding on the size, strength of the bench, including the judges in the bench. That's the reason he is called first among equals, right? This entire issue of the CGI being the master of the roster, being the ultimate authority to decide on all these matters, was challenged by late very famous lawyer Shanti Bhushan in this case in 2018. However, Supreme Court clarified that there is no question to be raised on the authority of the Chief Justice to be the master of the roster. The petitioners wanted this task to be given to a 3 or 5 judge collegium. However, Supreme Court disagreed and said that no, the CGI will continue to be the sole authority, the single person who will decide on the allocation of cases will be called the master of the roster. Right? In fact, it was this case where Justice Sikri famously used Edmund Burke's words and said, "Applaud us when we run, console us when we fall, cheer us when we recover, but let us pass on. For God's sake, let us pass on." So these were the words of Edmund Burke, but used by Justice Sikri, referring to how the Supreme Court always comes under contention from all corners. Right? This is something we are witnessing right now as well, where everybody has an issue the moment the Supreme Court judgment does not align with their understanding, their point of view, their idea of things. Anyway, so this question has its answer as C. Moving on to the fourth question. As per Part 1 of the Indian Constitution, which statement correctly describes the territorial division of India? Article 1 declares India as a sovereign, socialist, secular, democratic republic, setting the stage for the rest of the Constitution. Now, of course, this is not correct. We know very well Article 1 talks about what? India, that is Bharat, shall be a union of states. This article was under a lot of contention recently with respect to how it was being seen that the ruling party was trying to wrongfully, we don't know why wrongfully, but it was seen that the ruling party at center was trying to rename India into Bharat. Sadly, the people who were raising this concern did not know maybe that India is called Bharat in the constitution as well. Anyway, India is a sovereign, socialist, secular, democratic republic. These words are mentioned in the preamble. So, not under Article 1. The term Union of States was chosen to denote that the Indian Federation is a result of the states' indestructibility. Now, this is wrong. The phrase Union of States denotes this fact that India is a country where states cannot move out. There is no way you will leave this country. That is what the Union of States denotes. And anyway, states in our country are destructible. Their boundaries can be modified, their names can be altered, their areas can be diminished using Article 3. Unlike the American Federation, which is based on the destructibility of the states, no, in fact, in the American Federation, without the consent of the states, you cannot modify their boundary or their names. So B is also wrong. Look at C. India is a federation of states and union territories with the power to alter state boundaries resting solely with the state governments. Of course, state governments have no say in the modification or the alteration of state boundaries. All that is needed is that the center will seek the opinion of the concerned state, and let me just tell you something very clearly. This opinion of the state, is it binding on the center? Not at all. Article 3 gives this authority to the Parliament, that Parliament by law a simple majority can modify the state's boundaries. So C is also wrong, making D of course the right answer. And what's that? India consists of states and union territories, and the parliament has the power to admit new states, form new states, alter boundaries, and change the names of existing states or union territories. Absolutely correct. D is the right answer. And the last question for today. Consider the following statements. Article 16 guarantees equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Absolutely correct. Just like Article 15 talks about general non-discrimination, plus the 3 additions made to Article 15 talk about reservation in educational institutions, Article 16 talks about non-discrimination in matters of government jobs, public employment, and no discrimination to be done on the grounds of RRCSP, that is, religion, race, caste, sex, place of birth, and beyond that, of course, residence as well as descent. On these grounds, no discrimination to be done. Second one, it allows the state to reserve vacancies in government jobs and posts for members of backward classes that are not adequately represented in the services under the state. This is absolutely correct. This is Article 16 Clause 4, a provision which has been there since the commencement of this constitution, that the state can reserve seats, can provide for reservation in government jobs for those groups which the state feels are not adequately represented in the government jobs. Number 3, Article 16 applies exclusively to Indian citizens and does not extend to overseas citizens of India or non-citizens. Overseas citizens of India are of course not Indian citizens. And yes, Article 16 is meant only for Indian citizens. Just to clarify, there are 5 articles meant only for citizens of India: 15, 16, 19, 29 and 30. These are meant for Indian citizens only. This makes 3 also a correct statement. And the fourth one, both center and states can make laws to provide for residence as a criterion for reservation. Now, center, of course, Article 16 says that there will be no discrimination on the grounds of residence. However, Clause 3 says that Parliament has the authority to provide residence as a criteria. And again, Article 35 says the same thing, that Parliament can make laws to provide for residence as a criteria. States cannot make laws. Center can make laws, not the states, which makes statement number 4 as incorrect. So, how many statements given above are correct? C. Only 3 statements are correct. And this brings us to an end of our discussion on the Polity Daily Drill for today. Let's meet in the next video. Till then, that's all for me. Jai Hind.